Looks like everyone is ready. We've just used our mic system, so I'm pretty sure they're working. We don't need to do anything online for this one, so I don't believe we need to do a sound check. It's my understanding that Allison Kanne will be giving the argument and Christine Branstad will do rebuttal. Is that correct? Yes. Okay, thank you. And Mr. Weinhardt, you'll be arguing on behalf of the plaintiffs? That is correct. Thank you. Ms. Kanne, you may proceed.
May it please the court, counsel. My name is Allison Kanne. I'm arguing today on behalf of the appellant, Jason Carter. I'm going to remove my mask. The record in front of you requires vacation of judgment for 3 central reasons. First, because Jason Carter did not have access to the evidence that was available and known to the plaintiffs at the time of the civil trial. Second, because the evidence that was unknown to Jason at the time of the civil trial was both admissible and reasonably would have changed the outcome of the civil trial. Third, because the district court erred by allowing the state to provide targeted, seemingly inculpatory evidence to the plaintiffs, and also by refusing to continue the trial so that Jason Carter would have had access to the exculpatory evidence that existed at that time. We are asking this court to reverse and remand this case back to the district court for new trial. At the time of the civil trial in December of 2017, Jason had knowledge that there were 2 suspects to the murder of Shirley Carter, those suspects being Jason Carter himself and Bill Carter. And that is what his counsel and he based his trial strategy and preparation on at the time of the December 2017 trial. After the conclusion of the December 2017 trial, Jason was charged with homicide in the 1st degree and criminal discovery began. It was at that point that his counsel became aware of significant exculpatory evidence. In May of 2018, Jason Carter filed his first petition to vacate based on newly discovered evidence which could not have been discovered with due diligence at the time of the civil trial. This evidence was material and relevant and reasonably would have changed the outcome of that civil trial. After filing the first petition to vacate in May of 2018, plaintiff's counsel announced to the press that none of the evidence that formed the basis of that petition to vacate was new to them, and that they'd had the opportunity to discount it. We now know that plaintiffs also were aware of the alternative suspects as early as November of 2016. Never, in their interrogatory responses or in any other form of discovery, did they disclose their knowledge about the alternative suspects. If we had known that there were alternative suspects to this crime, it would have done a number of things. First, we would have had the opportunity to investigate. Second, we would have called those witnesses to the stand, potentially, or we would have done what we ultimately did in the criminal trial and call law enforcement to the stand to testify about their failure to investigate this case. The district court ruling on the petition to vacate was incorrect for 2 main reasons. It denied the petition to vacate for these 2 main reasons. First, it found that the evidence that—
I have a question for you. And at the criminal trial, I assume, based on the briefing and what you said, there was no issue regarding the admissibility of the reports with respect to the failure to investigate.
Your Honor, there was an issue in that it was presented in the context of a motion in limine, and we did have a hearing on it in front of a different judge in the same district court for Marion County. That judge did rule exactly the opposite of how the district court ruled in this case. In this case, the district court ruled that the evidence was inadmissible and therefore it could not have changed the outcome of the civil trial. It also said it was not material because it was inconsistent with the known facts at the time of the December 2017 trial. The district court case in Jason's criminal case ruled exactly the opposite, and that ruling is a part of the record in front of you. In that ruling, he said that we had presented him with over 75 examples of law enforcement's failure to investigate, and that it was very clear that we were not offering this evidence for the truth of the matter asserted, which is what we argued to the district court in this case. What we had were reports that were first reports and no follow-through whatsoever. The lack of investigation in this case has been extensively briefed, and it is shocking. For example, in January of 2018, law enforcement learned from a witness that another person, or that she had heard a confession from one of these alternative suspects, and that someone else was present in the car at the time she heard that confession. That person was never interviewed until January of 2019, just months before his criminal trial. In October of 2015, they did a first interview with one of these suspects, and that person said that his alibi was another woman. They didn't interview that woman for 3 years. And when they interviewed her, they told her, first thing, you're this person's alibi.
Counsel, if I might, it's my understanding that that Jason moved to quash the subpoena to DCI, and the court overruled that. Is that?
Yes, Your Honor.
That's right. And then there's now an argument being put forward that they didn't produce enough information at that time, that DCI didn't. Is that right?
In a way, Your Honor.
I'm just trying to square those two things, right? It seems like on one hand, the argument is that no information should have flowed at all, and now the argument is sort of the opposite, that not enough information flowed, so.
Well, I think they're two separate issues. The new evidence is the new evidence, regardless of whether or not it was part of the motion to quash. It's still new evidence that we could not have discovered. And that ties back to, in July of 2016, plaintiffs submitted their first subpoena to DCI and requested entirely, or almost entirely, the criminal file at that point. DCI filed its own motion to quash, in which it said, there is no basis in law to require DCI to give files from a confidential, ongoing criminal investigation to a civil litigant. In particular, it said, where there is a suspect who would be one of the parties receiving that information. So from July of 2016 until April of 2017, we were under the distinct impression that DCI would under no circumstances provide this evidence to either of the parties. Then
But that wasn't so, though. They ended up both getting the same amount of information in that civil case, correct?
No, Your Honor. In April of 2017, plaintiffs submitted a second subpoena to DCI. Now, of course, we learned at the time of the hearing in June of 2017 that they had been having discussions with the state determining the parameters of the subpoena. And we don't entirely know what the contents of those discussions were because we weren't invited to it. But what we do know is that in November of 2016, they had knowledge of these other suspects because they asked Jason Carter about them in his deposition. At that point, we had no reason to believe that these people were the subject of over 30 reports tying them to the scene of the crime, and that there were multiple confessions to the crime.
Let me back you up a minute on where Justice McDermott was going. That first subpoena, and then it was the state that actually did a motion to quash, and then there was apparently a hearing or an understanding. And didn't the district court enter an order, or at least a new subpoena was issued along the lines of whatever was discussed, and whatever information was provided by DCI, which they determined what they'd let go of, went to both parties? Isn't that correct?
Yes. In response to the subpoena from April of 2017, we received the same information that the plaintiffs received from that subpoena. The point I suppose I'm trying to make is that is not the only information that plaintiffs received. It was not just in response to the April 2017 subpoena, because we know they knew about those suspects a year earlier than that.
And so then is the argument that the plaintiffs failed to turn over information in discovery?
Yes, Your Honor. That was one of the bases that we moved upon for a new trial, was plaintiff's discovery violations, based on those two things. The fact that they had asked and clearly knew about these individuals at the time of Jason Carter's deposition in November of 2016, and the fact that plaintiff's counsel then went to the press after we filed our first petition to vacate and said, none of this is new to us. We had the opportunity to discount this evidence based on a, quote, complex analysis of lots of factors. If discarding these potential other suspects required a complex analysis of lots of factors, that required plaintiffs to disclose it to us. We had relevant interrogatory requests that asked them to describe every communication that they had had with law enforcement. And that is in the record at the amended appendix 1154.
Which suspects are you saying that plaintiffs did not share names of?
That would be John and Joel Followell and Callie Shin.
It's a heavy record. But I have a recollection that Agent Koos, or however you pronounce his name, did mention Followills as suspects before the civil trial.
Yes, Your Honor.
And there's a recording to that effect.
Yes, Your Honor. When it became clear that law enforcement was going to be able to, or was going to be allowed to testify at the civil trial, defendant's counsel met with Detective Caius. He recorded that meeting. He also testified, and this is in the record, that he had had many, many meetings with plaintiff's counsel, none of which he recorded. So he recorded the meeting with Jason Carter's counsel, in which Jason Carter's counsel asks repeatedly for information about other suspects. Detective Caius brings up the Followell brothers, and he says there was one report, Adam Glover, and it's not credible for these million reasons. What we didn't know at the time was it wasn't just one report. It was 30-odd reports indicating these other suspects. What he said to us at that meeting was not enough to put us on notice that these people were the subject of so many reports and so much evidence tying them to the scene of the crime, including, again, confessions.
You think giving the specific name of someone's not enough notice that you should look into it?
Not at that point, Your Honor. First of all, we were also a week before trial at that point. I don't know what we could have done with that information at that point in time.
That reminds me, I want to jump to the motion to continue. Wasn't the first motion to continue actually by plaintiff?
This case was continued a couple of times, and it was supposed to go to trial in March of 2017, and it was continued, not at the request of either party, I don't believe. There was an issue with the Jasper County Courthouse, and so there was no space for us at that point in time.
So when you, or whoever's on behalf of Mr. Carter, Jason Carter, when that motion to continue that is a subject of the appeal, wasn't that requested on either day of or day before jury trial commenced?
It was, Your Honor. And that was because it was at that point, if you read the transcript, and I think it was December 5th of 2017, we were having extensive conversations with the Attorney General. Counsel was we were met in chambers, but it was on the record, discussing the parameters of what we could and could not ask law enforcement. Because you have to remember, out of the mountain of exculpatory evidence, this file, the criminal investigation file, was mostly exculpatory evidence. And they chose the one piece of evidence that seemingly inculpated Jason, which was the fingerprints.
Counsel, did the defendant ever send a subpoena to DCI?
No, Your Honor, Jason did not, and that is because of the motion to quash that DCI filed in July of 2016, where it said, based on Shanahan, based on 62211, based on 2275, that there is no basis in law to require the DCI to provide information to civil litigants, particularly when one of them is a suspect, at this point, Jason Carter. DCI made its position very clear. And
But once it did produce documents, at that point, why wouldn't Mr. Carter do the same and issue a subpoena?
Well, Your Honor, what we learned at the hearing in June of 2017 was that they had discussed the parameters of the subpoena and that they had picked and chosen certain things. We weren't a part of those conversations. And what we said to the court at that time was, none of this evidence should come in because we don't know what is in the rest of the file, or all of it should come in because there may be exculpatory evidence. Whether the court decides that DCI should have given none or all of the evidence doesn't really matter, because what happened in this case cannot be affirmed. This was gamesmanship of the system. The state and Bill Carter shared a similar goal: prove that Jason Carter murdered Shirley Carter. And they collaborated to the exclusion of Jason Carter, provided the one piece of evidence that made him look guilty out of the mountains of exculpatory evidence. And we were handcuffed.
That sounds pretty convincing in a criminal case, but we're talking a civil case.
Yes, Your Honor.
And in the civil case, in that arena, that subpoena, DCI can be picky. They're the ones who, it's their privilege, and they can say, I'll give you this, I'm not giving you that. Would you disagree with me that they're the ones who get to determine what gets out the sieve?
In a manner, Your Honor, I think we're not saying that DCI loses its discretion entirely about whether or not it can release information.
And it sounds like you want all or none, and they chose to give some.
If they
and you
chose,
could have asked for more and didn't?
well, we moved for a continuance so that we could have access to all of the files when the criminal investigation was closed. Because DCI told us in their July 2016 motion, this is an open investigation. We're not giving the entire criminal file to the suspect.
When did DCI produce the documents in relation to when trial actually started?
It was sporadic. There were different, I know that the fingerprint evidence came in very, very close to trial. It might have even been like the day of trial. But there were other pieces of evidence that are not as relevant, which were the interviews, transcripts with Jason Carter and Bill Carter. That was one of them. So between the hearing in June of 2017 through the actual trial date.
Just so I understand your theory of materiality.
Yes.
It doesn't really matter, as you're positioning it, that maybe even your client or counsel might have known the name of a suspect or two suspects. It's that there was this mass of reports that the DCI and local law enforcement failed to investigate that would be exculpatory and would have changed the theory of trial. That's, or maybe you would, I don't know how it would have changed it, but that's your theory, right? That the name is not enough, you needed the documents.
Yes, Your Honor, and asking two names in a deposition is not the same as disclosing it in responses. We did our job by asking relevant discovery requests, and they failed to provide answers to those requests. They failed to supplement. When they learned that these other suspects existed, they had the obligation to disclose it, especially when they had the opportunity to discount them based on a complex analysis of lots of factors.
You may wrap up. You may wrap up.
Your Honors, the evidence that is now available to us would have changed the outcome of the civil trial, and this is perfectly exemplified by the fact that it did change the outcome, or we did prove in Jason Carter's criminal case that this could have changed the outcome of the trial.
I do want to make a comment about that, but that would be completely beyond a reasonable doubt as opposed to the civil standard, correct?
That is true, Your
Okay.
Honor.
Yeah, okay, thank you. Mr. Weinhardt.
May it please the court, counsel, Bill. We are now in the 6th year of an unimaginable tragedy for a husband and a father, Bill Carter. We are now in the 4th year of trying to get finality for the jury verdict that was returned in this case. It is time for some small measure of justice for Bill and his wife's memory. One proposition illuminates and really answers almost all of the issues in this case, and that is that the evidence overwhelmingly demonstrates that Jason Carter killed his mother. And it does so in a way that excludes almost all of the evidence that is not impeaching or cumulative in support of both the first and the second petitions to vacate, because the petitions to vacate both depend, although there are lots and lots of names referenced, on the same fundamental proposition, that some stranger burglar or burglars surprised or were surprised by Shirley Carter in her house, and in a panic, somebody shot Shirley Carter. However, at the trial of this case, both sides called extensively credentialed and experienced crime scene reconstruction experts. Both sides' experts agreed that the burglary robbery scene in the house was faked, and that the thing that you could infer from that was Shirley knew her killer. Cash, a checkbook, a purse, prescription drugs, firearms were all in open view. Nothing of value was removed from this house.
The two expert comment that you made, I remember seeing in the record that both plaintiff and defendant's expert agreed that it appeared to be a staged burglary, correct?
Right.
Am I correct also, and will the record support that both experts believed that the defendant, or that the victim knew her assailant?
I think our expert Webb explicitly said that. I think their expert Rini, that would be the obvious assumption from what it was that he said, but I don't think Rini explicitly said that.
Thank you.
But another critical fact, Shirley did not die in a violent or contested moment. She died in a moment of peace. She was wearing her socks. She was in the transition from taking off the mud boots that she wore when she did chores in the barn and putting on the sneakers that she wore in the house. Bill's testimony about that is in volume 4 at 71 and 152. And so there's nothing about
Mr. Weinhardt,
Yes.
what is the materiality standard? Would the evidence have made a difference given the way the case was tried? Or is there some avenue that the entire trial strategy may have been different, and maybe they wouldn't have called a crime reconstruction expert if these exculpatory reports had been made available.
In a civil case, the standard for relief is enunciated by Benson versus Richardson in the cases that it rely on. And that standard is there has to be a showing that the new evidence probably would have changed the outcome at a second trial. And so the district court's job is to hear the evidence produced in support of the newly discovered evidence claim, put that evidence into the mix, and determine if the second trial comes out differently. And that's what Judge Mertz did below.
But does that presuppose that the hypothetical second trial is tried under the same theories, but with different evidence, or is the hypothetical second trial one that may look radically different now that there's a lot of different kinds of evidence available to the parties?
So I would submit that in a civil case, and for that matter, in a criminal case where there is no Brady violation, the newly discovered evidence does not permit the defendant to change his theory in the second trial. That's what this court held in Smith. That was one of the reasons why the defendant in Smith lost. The only cases that talk about a strategy change are the cases that they cite that without exception flow back to the Brady doctrine. And the Brady doctrine is inapplicable here for two reasons. First, as a matter of first principles, it comes from the Fifth Amendment due process clause, which only binds the government, and we are not the government. Secondly, as a matter of practice, we put the thumb on the scales in favor of the criminal defendant because we are so worried about the anathema of a wrongful criminal conviction. And so we are willing to tolerate the risk of wrongful criminal acquittals. We're willing to tolerate years and years of litigation in order to avoid a wrongful conviction. But in a civil case, the values are absolute fairness between the parties, no thumb on the scales, accuracy in the decision-making, and finality with reasonable promptness. All of those things argue against allowing the defendant to make this "my strategy would have changed" sort of argument.
Counsel, I'm sorry, you go ahead.
I feel like at least one of those three may argue for allowing a strategy change, which is accuracy in the fact-finding process. I understand finality in the other piece, but if the plaintiff receives a mountain of exculpatory evidence after trial that they weren't able to obtain, I don't see how accuracy in the fact-finding process requires them to be wedded to a trial strategy that they had to present based on the evidence they had.
Well, first of all, for this court to affirm, I don't need to win any of that argument. And here's why. For the reasons I've stated and a number of others, including all of the many things that Jason knew that only the killer could possibly know, the evidence here demonstrates that the stranger burglar theory isn't true and that Jason is the killer. The district court found that the evidence in support of the stranger burglar theory was absolutely incredible. It did not square with the known physical facts of the crime scene. It consisted of ruffians telling rumors from the county jail because they were trying to make deals. The statements were completely internally inconsistent with each other. They had the wrong kind of gun. They had Shirley being waterboarded in a pond outside when there was no evidence that she had ever left the house. And so, just as a matter of substance, that theory did not work, and the district court, which is reviewed for abuse of discretion on this, determined that the evidence, even if credited, did not carry the day. In addition, in order to be capable of probably changing the outcome of the trial, the evidence would have to be admissible. And here, they did not produce any admissible evidence. All of the evidence in support of the stranger burglar theory came from civilian witnesses. They didn't call a single civilian witness at the hearing on the first petition to vacate. If one looks at page 38 of their brief, one will see what happens. A guy named Followill says something that might be relevant about this murder to a lady named Durham, who
Counsel,
says
if
it
I might, on the argument that the defendant makes relating to the discovery that wasn't turned over. What's the plaintiff's response?
First of all, we had no document, no report, no nothing that they didn't have. Based upon some rumors in the community, Mr. Danks, before we got into the case, asked some questions about alternative suspects of Jason Carter in his deposition. That was it. I will own the statement made to the media about nothing of substance, but the words were of substance because we knew after having looked at their petition that there was nothing that was going to be admissible and that there was nothing that was going to be probative in order to change things. The district court ruled expressly in its second ruling from June of 19 on the discovery question, and they have not referenced that ruling or attacked it in either of their briefs. And as far as what came from the DCI, both sides at all relevant times had everything from the DCI. We didn't keep anything that they didn't have. Certainly from our involvement in the case early in 2017, we gave everything to them as soon as we got it. So the parties were on an absolutely equal footing in terms of knowing the names of these other suspects and in terms of any sort of documentary information that they had about these other suspects. What's striking about this instead is that their statement that they want the entire criminal file or none of the criminal file is just not candid with this court. Their chosen strategy throughout the proceedings up to this trial was they were running away from the criminal trial. They didn't want any of it. That's why they didn't serve their own subpoena. Once we had a subpoena and had some information come our way, they might have had a pretty good argument to serve a subpoena on the DCI for exculpatory evidence, and then if DCI didn't comply, to say to Judge Mertz, look, what's good for the goose is good for the gander. We ought to be able to have some level playing field here. But they didn't do that. They elected not to try to get anything from the state. I also want to dispel this idea that there was this cozy cooperative relationship between us and the AG. Indeed, we fought like cats and dogs about this. We always thought that they should have been releasing more than they did. The first version of the subpoena thing, before our firm got in the case, resulted in litigation. The only reason we had a meeting with them before the second subpoena was so that we could try to have the settlement negotiation in advance of the motion being filed instead of after. But we didn't get everything that we wanted. And what we got didn't have Jason's name on it. It wasn't targeted to him. It was neutral. And if the court looks at the first appendix at pages 50 and 51, the court will see a list of what we asked for, and we didn't get it all. But what we got were the crime scene photographs, we got the forensic pathologist's report about how Shirley died, we got the transcripts of the recorded interviews of Bill and the recorded interviews of Jason, we got the ballistics information that helped identify the murder weapon, and we got fingerprint information regarding two objects, the gun safe in the basement from which the murder weapon originated and the search warrant manifest that Jason claimed under oath that he never handled, but had 24 of his fingerprints on it, or 22, or somewhere in that number, which, by the way, Jason 12 hours or 10 hours before he saw that manifest, called up the sheriff and asked about the .270 rifle, revealing that he knew that was the murder weapon before anyone on earth knew that a high-powered rifle was the thing that killed her. In any event, we didn't...
How long was the criminal jury out?
Each jury was out almost the exact same time, about 2 hours.
2 hours.
But I would say that first, as Chief Justice Christensen has mentioned, in part, that is an artifact of the difference in standard of review or the jury's burden of proof. But also, it is a reflection of the fact that the district court in the criminal case, as we understand it, and we didn't participate in that case in any way, shape, or form, allowed all of this hearsay evidence about other suspects purportedly under the guise that it was not admitted for the truth of the matter asserted. And with due respect to that court, that was a tragically wrong decision that turned that case into a circus. And the district court in our case made the correct decision about that and held that all of that hearsay evidence was inadmissible. Indeed,
But at least doesn't that tell us something? That I understand it's your position that there's overwhelming evidence of Jason's liability in this case, and that the stranger burglar theory is wholly inconsistent with all of the evidence and ridiculous and jailhouse informants. I understand that position, but at least in the criminal case, and I understand we adjust for the burdens of proof. This didn't seem like a particularly close case for acquittal, at least for the jury in that case. I mean, can't we infer that maybe there is something there to his theory, or at least it would have made some sort of difference in a civil trial?
I don't think this court can do that if the criminal case is not part of the record, which the district court decided not to take judicial notice of it. That decision, we believe, was correct. The decision is not challenged on appeal, yet through the side door they kind of want to talk about it. But the case was tried by different lawyers on the side accusing Jason, espousing, we think, some somewhat different, and frankly, I don't think we would agree with theories, and hugely hobbled by what we would submit was this incorrect decision about the evidence. And even if that decision was correct in the criminal case, it wouldn't apply to us because we're not the state. And so the defense that the state's investigation was insufficient doesn't work and wouldn't be admissible against Bill Carter. Just to wrap up, unless the court has any other questions, I want to make plain, despite the complexities that we've gotten into, the injustice that we are trying to battle against here. All of us are sitting in the same room with a killer. He walks around a free man, and despite his astounding good fortune, he is here with his hand out, asking this court to relieve him from a money judgment to which he has not made the first payment, despite the mounds of resources he devotes to this case, the freestanding equity case that parrots the second petition to vacate, a state court lawsuit against law enforcement, and a federal lawsuit now dismissed and on appeal against his father and law enforcement. It is time for a modicum of justice for Shirley Carter's memory.
Thank you. It's my understanding Ms. Branstad will go next. If you want to use the middle microphone, you're welcome to. If you don't mind sharing, that's fine too. That's what we've done when we've had 3 attorneys. We're trying to keep things COVID-friendly.
Let me just start with one of the statements made by counsel in trying to say that there is a mountain of evidence against Jason Carter. He mentioned the murder weapon. There is no known murder weapon. There is a suspected weapon. Now, counsel stated, and this is just one of the many pieces of evidence that came up, that Jason Carter asked days after Shirley's death about that weapon. But what he doesn't mention, and what came up in the new evidence, is that Billy Dean Carter asked about that weapon upon arrival at the scene. Clearly,
Said something to him according to the record, and then it's alleged that Dad then repeated what he'd heard from Jason.
Billy Dean, who is the brother. So,
Dad, but regardless, I'm getting the Billy and the Billy Dean mixed up. But wasn't that based on something that was told to him allegedly by Jason?
that was just his first statement upon arrival. And Billy Dean admitted that was the first thing that he said upon arrival later on. And Your Honor, I'm sorry, I don't think that's part of this record, but there are numerous pieces of evidence. One of the things that counsel said is that it was purportedly for the purpose of attacking the investigation. Well, Agent Ludwig's testimony is part of this record, and I think this court need only read that testimony to know what the purpose was at that time. But the new evidence could be used either to attack the investigation of law enforcement or for the purpose of showing the culpability of other suspects. It's incorrect, I believe, that evidence need to be presented at the motion to vacate in its admissible form at trial. At trial, those witnesses would need to be called, but I believe Harrington shows that that information just needs to be presented in a way that shows it could lead or would lead to admissible evidence. And Your Honor, certainly, for example, if Charity Roush was called and she said, I heard specifically a confession, it was consistent, it said they were in the middle of a burglary, that they were interrupted, that they'd gotten into some of the drawers, and that Shirley Carter was shot twice. Those statements made without any knowledge of what the testimony was at trial, certainly that could be used to show that there was culpability of other suspects. So there are two ways that this information can go.
If the plaintiff is right that the experts in this case did not find that there was any substance or any weight that should be given to this stranger burglar theory, what are we to make of that?
Well, that was without any of the information about the confessions and the statements that lined up with the evidence. Once we have individuals saying that they were in the house, that they were interrupted, that they'd gotten into drawers, that there were 2 shots fired before there was any information that there were 2 shots involved, then I think it takes a different look at it. Because what the experts really said was it was unlikely. They couldn't eliminate that it was someone else. It was based on the information that they had.
Experts looking at the actual physical evidence?
Your Honor, they're looking at pulled out drawers and items that were not taken, but there is nothing that they could say that would eliminate it being other people. It's what it looks like based only on that. But now we have confessions and a weapon that could match the murder weapon that was sold by one of the people involved and was recovered and can't be eliminated as the murder weapon.
Mr. Weinhardt's argument that as we're looking at the question of materiality, we examine that or assess that in light of the case as it was actually tried and not under some sort of reconstructed theory of the case, because those cases rely on Brady violations.
I think State versus Smith says that you don't need to have the same theory of the case and that you can go forward with a different theory. But in this case, it isn't actually a different theory. In closing, counsel for Jason Carter did say it may be Bill Carter, it may be someone else. So it isn't a wholly different theory. I think Jason Carter's theory was always, it wasn't.
I have one other question for you. Recently, we filed a case, State versus Uranga, that addressed a motion for new trial, a little bit different than the petition here. But the gist of it was that a party is not entitled to relief unless they've made reasonably diligent efforts to obtain information that could have been available to them. So my question is, upon the DCI deciding to waive privilege and produce some documents, why isn't it incumbent on your client at that point to say, what's good for the goose is good for the gander? Here's my subpoena. I want all of the documents. And if you don't do that, then there's no showing of diligence.
I think that it's really tough to say, well, I think that this subpoena was not permissible. We'll try and get an impermissible subpoena too. I think you have to have a good faith basis that you have the right to that. And under Shanahan and Mitchell, I think that the court has to make a public policy weighing of the benefit. At the time when the initial subpoena was entered, the court made it very clear that they were not going to order everything to be released. Again, when the second subpoena was issued, counsel for Jason Carter did state that if it was going to be some, it was going to be all. It wasn't another subpoena issued, but there certainly is record that that was the record made. And I think the court in its ruling agreed that that information was not available to Jason Carter at the time of the civil trial. I think that's within the ruling of the court. So I think it was very clear it was not going to be available. Your Honor, I believe that simply by looking at the immense amount of evidence as shown in the 2 petitions to vacate, and by listening to the recording at C6, this court can see that this simply was not information available to Jason Carter, and we would ask that this court reverse and remand this case for trial.
Of Carter versus Carter is hereby submitted. And also, as previously stated, the case of Johnston versus Iowa Department of Transportation is submitted without oral argument, and court is adjourned for the day. Thank you, everyone.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.